Well, I just want to make sure that you answer the question I asked.
I told you what happened. Did you hear my answer, madam?
Keep the answers confined to the questions.
Well, it's highly offensive when someone lies on you.
We're getting way afar.
Perhaps you could lead the witness.
Isn't it true?
No, I need to explain this. I'm not a hostile witness. Extremely offensive.
Is ignorant, doesn't know what he's talking about.
DA Fani Willis unintentionally gives us insights into what unreliable answers sound like. This is important to be aware of in our own daily conversations. What makes Willis's statements unreliable? And what does her way of answering tell us about her personality and mindset? Willis is accused of having a relationship with Special Prosecutor Nathan Wade before and during the time they were investigating Trump. What do you think about Willis's dramatic testimony? Let us know in the comments. Time to get the show on the road.
Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
In a setting like this, it should be noted when the speaker answers a question with a question.
This first January motion?
This buys the subject more time to think about what to say. Thus, it's a possible indicator that the question is problematic for the subject. It isn't deceptive in and of itself, especially if it's a complicated question, which isn't the case here. But it should be noted along with other linguistic findings.
Your security team has never taken him?
From my house?
Have they ever taken the two of you together?
To where?
Anywhere.
Another thing to look for is hedging language or vague language, verbs and adverbs that express uncertainty rather than certainty.
I don't know if you could say talked about. I probably had some choice words about some of the things.
Vague language grants the subject leeway to modify or retract a statement at a later point without directly contradicting it. And here, the hedge is open for a battle of semantics. What constitutes as talked about? Willis is asked about a specific event, an event she's expected to remember, so the adverb probably is unexpected. Overall, this is a stalling, if not evasive answer, and it's also an antagonistic answer. Willis's voice is shaking, and also she uses the personal pronoun you repeatedly. First, she says you could say as opposed to I would say.
I don't know if you could say.
Addressing the lawyer directly. Then she says you said and you know.
About some of the things that you said, as you know.
This way, Willis behaves as if it's the lawyer on the stand, as if the lawyer has some explaining to do, and not her. So when she says,
Mr. Wade is a Southern gentleman, me not so much.
I believe her. In the following, Willis is annoyed with the lawyer repeating the question. Her reaction is telling.
Okay, but my question was, did you have a conversation with him?
I didn't have a substantive conversation.
You did not?
I read this motion, skimmed it more so, and I've probably said some choice things to him about some of the lies they were told.
This is telling because Willis's overlap, intonation and word choice all indicate that she has answered this question, when the truth is her previous answer used hedging language and disputed the words talked about. In other words, the most important thing to Willis is to portray the lawyer in a negative light. Apparently, it's more important than giving unambiguous answers the first time around. However, does she actually give an unambiguous answer this time around? Not if we consider the adjective substantive. Once again, she opens for a battle of semantics. This time, it's about what constitutes a substantive conversation. This is self-protective language that reveals that Willis is highly self-aware. This self-awareness is underlined by her pauses and interjections. After Willis's inconsequential distinction between reading and skimming, inconsequential in regard to her testimony, Willis makes an interjection followed by a pause while licking her lips, before getting to the relevant part, the part that could damage her testimony, what she said to Wade. Thus, the lawyer does need to ask Willis if these simple questions make her feel pressured or nervous. With her speech behavior, Willis is saying it without saying it. Then, when it's time for the relevant part of her answer, she resorts to repetition of the hedge, probably.
I've probably said some choice things to him about.
So she's able to assert that she skimmed it as opposed to read it. But not if she said some choice words. How convenient. The pressure that Willis's language indicates that she feels is further indicated by the fact that she's upgraded dishonest to lies.
Things that you said that were dishonest with some of the lies that were told.
The pressure manifests itself as rhetorical attacks on the lawyer. Next, Willis plays on people's indignation, delaying the lawyer's questioning, as she shifts to the collective pronoun we. This part works better with music.
Okay.
And then printed in the media because, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Politicians often play on the indignation of certain demographics whose votes they want as a way out of giving answers to questions that are specific to them. This conveniently makes it look like the politician isn't the only one under attack, but that it's a general problem.
Well, I just want to make sure that you answer the question I asked, though. So my question was...
Overruled, Mr. Abadi.
I told you what happened. I read the motion.
She read it now. She didn't just skim it.
Skimmed it more so.
Again, Willis uses the pronoun you, addressing the lawyer directly, and makes her previous answers sound like they were specific and conclusive.
I told you what happened. I am sure I told him what my opinion of it is.
Okay.
And past that, we had no substantive conversation.
The real question is how she defines substantive. She keeps adding to her original answer. Now she says she's sure she gave her opinion, rather than just some choice words, which, ironically, doesn't sound like she's sure at all.
Some choice words about my opinion of it is.
Willis's argument hinges on the presupposition that giving an opinion isn't substantive. With this, it's made clear why subjects introduce modifiers like substantive in the first place. They grant the subject leeway to modify, add to, or retract their statement without directly contradicting it, all in the name of linguistic self-defense.
Past that, we had no substantive conversation.
You did not. Okay.
Is there something you didn't understand?
No, I just wanted to make sure that
Okay.
you did not have a meeting with him in the conference room to discuss the motion.
Next question,
No.
Ms. Merchant.
So in the
Willis's behavior is indicative of someone who feels they're above answering, above being questioned. And again, she makes her previous answers sound a lot more assertive than they actually were. There's a lot that Willis hasn't shown interest in letting the public understand, and the lawyer represents the public in that regard. So once again, it's revealed that the most important thing to Willis is to portray the lawyer in a negative light. Next, this point is further underlined by the fact that Willis starts using hedging language again.
in the conference room of my office within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure who was giving it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. And I think he showed me a document.
Another potentially important detail that subjects are expected to recall rather than just think happened. She makes a distinction between this and a substantive conversation. I'm wondering, at what point does a conversation become substantive? She gives her opinion and she's shown a document, but none of it is substantive. Willis retracts her denial. When talking about the document, the speech rate increases, making the repetitive denial the part she wants to get to quickly. And again, all the audience has to go by is Willis's subjective presupposition of what substantive means. This is called a self-repair, the subject rephrasing what they were about to say. Self-repairs point to a problem in answering directly and clearly, and we should always be interested in finding out what this problem is. Grammatically, I would not have, as opposed to the conclusive I didn't, isn't specific to the topic at hand, and I don't believe is a hedge, indicating uncertainty. So this is where it's revealed that Willis isn't as assertive as she's pretended to be.
I have had conversations with him.
She just gave her opinion and was shown a document, and no one responded or said a thing, like in all conversations. Next, she continues to set a good example for how people should conduct themselves on the stand.
Let's start back in 2019.
Yep.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions you tried to implicate I slept with him at that conference, which I find to be extremely offensive.
Willis uses indignation, whether it's her own or playing on other people's indignation, as a means of focus shift, which is a classic diversion tactic. Focus shifts can be identified by how much a given statement deviates from the question. Here, the lawyer is asking a simple question about Willis meeting Wade. She doesn't even hint at a relationship. Ironically then, it's Willis's reactions that can make people think there was more between the two than she's letting on. It's not the lawyer's questions. And next, Willis gives details that give the impression that she's proving that there wasn't anything between them. These details, however, are inconsequential and function as distraction, delaying the lawyer's questioning. Let's watch.
I stayed at that conference. Mr. Wade was my teacher. I did not meet him when he taught the class. I was standing outside talking to Lisa Reeves, who is a judge. Me and her were just having a conversation. Mr. Wade walks up. I think they hug each other. They have some brief conversation. She introduces us.
Any more details you'd like to share? I'm just wondering, because I don't think we've had enough. Not only are these details inconsequential, or not substantive to use Willis' terminology, but Willis also makes an interesting shift from past to present tense. Present tense descriptions of what's supposedly a completed event can point to the subject rehearsing the event in their mind, because they aren't actually describing a completed event, because the event never took place. In this case, when we combine Willis's many details with her stalling, it's entirely possible that Willis shifts to present tense because she's self-aware, knowing that she's stalling. Next, Willis is stopped, as she, as a DA, very well knows is the outcome of this evasive answer. The stop buys her more time to think about which diversion tactic to choose next.
Your Honor, I'm going to object. We kind of thought that when you asked the question, you can answer the question, not a speech, so I object to the speech.
I agree,
I'm able to explain my answers.
But that's the thing. She doesn't explain her answer because she couldn't use her answer, so-called, to deny the relationship. She answered a very short question with inconsequential details.
I believe she's able to explain her answer.
And that's
Ms. Merchant, that's okay. I can handle it. Ms. Willis, I'll ask you just listen to the answer, or excuse me, the question, and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity.
Willis knows all this, so her diversion tactic seems to be working.
On when the state is
Well,
able
it's
to
highly
follow
offensive
up.
when someone lies on you, and it's highly offensive when they try
Judge.
to implicate that you slept with somebody the first day you met with them, and I take exception to it.
Tell it to the judge. Wait. Obviously, yes, it's offensive if it isn't true, but the point is that the lawyer hadn't even asked her anything potentially compromising. That's how the audience can be sure that Willis is stalling, using indignation as a diversion tactic.
All right, well, Ms. Willis, you'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did the meeting.
Okay.
That wasn't so hard to answer, apparently. She could have just said that and saved the court some time. But then again, she needed time for her diversion tactic to work. Willis got what she wanted from this outrage. It allows her to continue with inconsequential details and irrelevant observations.
He, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that conference.
Irrelevant speculations and observations should be noted as likely deception.
And I'm not sure if it was that exact class or we had went to lunch. She had worked at a law firm I worked at.
Irrelevant details are identified by asking counter questions like, who asked? Or, how does this deny or confirm the topic at hand? Just like with the word substantive, Willis moves the goalpost. It's irrelevant whether or not she met him when he taught the class, but Willis tries to make it sound like it's the most important point.
I did not actually meet him when he taught the class.
Willis really doesn't want to be asked about this meeting, and she's saying it without saying it.
But I literally just asked if they met at that conference.
Explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant. These answers are more than appropriate.
That's incorrect. The lawyer didn't ask her how they met. She made a declarative statement with the upspeak to signify that it was meant as a question, checking to see if she was correct.
Yep.
So you and Mr. Wade met in October 2019 at a conference?
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at a judge's conference?
We haven't gotten to the point where Ms. Willis should be treated also under 60.
I think we have.
I very much want to be here, so I'm not a hostile witness. I very much want to be here.
Not so much that you're hostile, Ms. Willis, it'd be an adverse witness.
Yes, because everything about Willis's facial expression and repetition of very much wanting to be there screams wanting to be there. So much drama from a simple and innocuous question. Willis got what she wanted, but she's not done with the diversion.
Your interests are opposed to Ms. Merchant's.
Thank you.
Merchant's interests are contrary to democracy, Your Honor, not to mine.
And now she's back to the bigger cause diversion tactic.
You know, we used to be in a day and time where you had 60 minutes and people did stories and they verified information.
It's just that now the DA doesn't even attempt to qualify her accusations.
Thank you. Merchant's interests are contrary to democracy, Your Honor.
Willis continues to get away with this behavior.
All right, let's
Judge,
proceed.
I would just ask that
We can keep things moving. Ms. Merchant, next question,
Thank you.
please.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
Yes, because that proves that she didn't have a relationship with Wade at this point in time. Next, we see the same pattern, the lawyer asking a simple yes-no question, and Willis giving an over-elaborate answer, which is the most effective way for a subject to buy time and get the upper hand in substantive conversations. Willis is asked about Robin, who's contradicted Willis's testimony about when her relationship with Wade started. Brace yourself for more irrelevant details, intentionally downplaying how close they were. Again, this part works better with music.
Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college of, I went to Howard University. She went to Morgan State. I met her through some people I knew. In college, we hung out a bit. Not much because she was in Baltimore and I was in Washington, D.C. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here in Atlanta, but we did not have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her. So she was in Atlanta.
Willis's outrage has made sure that the lawyer and judge don't interrupt her. Instead, she's allowed to continue to control the courtroom.
You have been friends with Robin for 30-something years.
Did you hear my answer, madam?
Yes, and I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years.
Once again, Willis is allowed to turn a simple clarifying question into a personal attack on the lawyer.
Did you hear my answer, madam?
Moving the goalpost with a new distinction. This time, it's not the word substantive, but the distinction between knowing someone for 30 years and being friends with someone for 30 years. The super important distinction allows Willis to give even more inconsequential details. It's the same pattern over and over again.
We certainly hung out and partied together in college. She was from the D.C. area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that partied together.
Yes, because you only party with people you aren't close with. When looking at Willis's answers in other contexts, we notice the same pattern of her going after the person who's contradicting her before she addresses what that person said. To Willis, everything's a power struggle.
According to Fulton County Court Administration, through a public records request, there were about 1,232 individuals at the jail as of August of this year who had not been indicted. Commissioner Ellis just 2 days ago talked about the unindicted at the jail, and he referenced 521 inmates at the jail that have been there more than 90 days who are unindicted. 60 of them have been there more than a year. And he said, quote, "If that's not pretty disturbing data, I don't know what is." What's your reaction to that?
That Commissioner Ellis is not a supporter of criminal justice, is ignorant, doesn't know what he's talking about most days, and is just not really trying to make himself informed of the issues or the progress. That would be my reaction to that statement.
The interviewer has to ask again to get her reaction to what's actually relevant, the statistics.
So what is the accurate number? Is according to the court administration, it's 1,200.
So the last time that I looked at the data, it was right around 1,200 for unindicted defendants in jail.
If you're excited about language, click the like button and subscribe for more substantive videos. Have a nice day.